Welcome to The Explainer. Today, you and I are putting on our skeptical legal analyst hats. We're looking at something that frustrates absolutely all of us who seek accountability. What actually happens when the justice system just stalls out completely? We're going to examine how bizarre anomalies, whether it's an impossible lack of physical evidence or a catastrophic human error right inside the courtroom, can absolutely break a case wide open. Okay, let's dive into this.
Here is our roadmap for this dual case study. We'll start with the physical mystery of a 1982 unsolved case, move through 3 suspects with 0 links, and then fast forward to a modern-day judicial sabotage, the paper trail, and finally, the retrial dilemma.
Starting with Section 1, the physical mystery, the 1982 Chicago Tylenol poisonings. This case represents our first massive fracture. And you know, what's so haunting about this tragedy is the sheer terrifying speed at which it all unfolded. Let's map out exactly how September 29th progressed. In the morning, a 12-year-old girl, Mary Kellerman, passes away in Elk Grove Village. By the afternoon, 27-year-old Adam Janis dies in Arlington Heights of what officials mistakenly think is just a massive heart attack. But here's where the tragedy compounds. That evening, Adam's grieving brother, Stanley, and sister-in-law, Teresa, go over to Adam's home to mourn. To deal with the stress, they take capsules from the exact same Tylenol bottle sitting right there on Adam's counter. Both collapse. Stanley dies immediately, and Teresa passes away 2 days later. The initial public health response entirely missed that this was a mass poisoning event.
It actually took the incredibly sharp eyes of one professional to connect the dots. Nurse Helen Jensen was the one who noticed a single store receipt and a single bottle of extra-strength Tylenol at the Janis home. That crucial, on-the-ground observation uncovered the lethal link to potassium cyanide. We've literally got to give her total professional respect here, because without her quick thinking, hundreds of further deaths could have occurred before anyone realized what was actually happening. And this brilliantly illustrates who we call the manufacturing paradox. We had contaminated bottles spread across entirely separate retail chains, Jewel Foods, Osco, Walgreens, Dominick's, yet testing confirmed these specific bottles came from completely different manufacturing plants, one all the way in Texas, one in Pennsylvania. This definitively proved the cyanide was not introduced at the factory level. It absolutely had to happen at retail.
Which brings us to the logistical impossibility that has haunted police for decades. I mean, think about the steps required here. The perpetrator had to manually shoplift dozens of bottles, transport them to a secure location, painstakingly separate the gelatin capsules, and pack them with highly toxic and very volatile potassium cyanide. Then reassemble the packaging flawlessly and reverse shoplift them back onto the shelves. And they had to do all of this, the whole shebang, without being spotted by a single store clerk or customer. Insane, right?
Section 2, 3 suspects, 0 links, frustrating dead ends.
So this is where the investigation hit those super frustrating dead ends. Investigators found individuals acting incredibly suspiciously, yet completely lacked any physical links to actually make an arrest. First up, James William Lewis, a highly intelligent tax accountant using at least 20 aliases. Next, Roger Arnold, a Chicago food warehouse worker, documented as having a bizarre fascination with chemical blending. And finally, Theodore Kaczynski, the Unabomber, whose early package bombings centered around Chicago, and whose parents happened to own a home right smack in the middle of the poisoning perimeter.
Now, what's really interesting about this is the sheer paradox of James William Lewis. In October 1982, he sent a handwritten extortion letter to Johnson & Johnson demanding $1 million to stop the killings. Yet an FBI manhunt proved he had an ironclad alibi. He was physically in New York City when the poisonings occurred. He literally could not have placed those bottles on the shelves. In bizarre fashion, despite his alibi, he later wrote a multi-page layout for the FBI detailing exactly how the killer must have done it, maintaining right up until his death in 2023 that the note was just an emotional outburst.
Then there's Roger Arnold. Investigators actually discovered he kept potassium cyanide inside his home. I mean, it seemed like the absolute smoking gun, but he was never charged because they couldn't tie him to the retail stores. Fast forward to 2010, the FBI formally exhumed Arnold's corpse from modern DNA testing. The result? A total mismatch with the trace profiles on the tainted bottles. He was completely exonerated.
And finally, Kaczynski. Geographic proximity placed him right near the danger zone in Lombard, Illinois. In 2011, the FBI requested a voluntary DNA sample while he was in Supermax prison. Kaczynski adamantly denied ever possessing potassium cyanide, and the forensic links remained entirely inconclusive. 3 perfect suspect profiles, absolutely 0 physical proof to close the case. It is the ultimate investigative frustration.
Before we pivot to our modern breakdown, let's move to Section 3 and see how this builds. The judicial sabotage, the Murdaugh verdict undone. Now, transitioning to our second case study, as skeptical legal analysts, we are going to entirely bypass Murdaugh's general biography today and look squarely at the foundation of this appeal: structural error. So the crucial point is this. It doesn't matter if the prosecution presented an absolute mountain of evidence against the defendant. If an official of the court contaminates the jury box, the trial process itself is fundamentally broken. The verdict is legally dead upon arrival. The official at the center of this structural error is Clerk of Court Becky Hill, and the alleged hidden motive here? It had absolutely nothing to do with justice. The allegations point to a rush for fame, media attention, and securing a lucrative book deal for her self-published title, Behind the Doors of Justice. Impartially speaking, the desire to commercialize a massive murder trial allegedly became the exact motive that completely derailed it. Moving on to Section 4, the paper trail, smoking gun transcripts. This is where the allegations transition into hard, documented proof. During the evidentiary hearings, it was revealed that specific jurors were heavily targeted. The most prominent was Juror 11, commonly known as the egg juror. Her dismissal from the jury was systematically carried out under highly suspicious circumstances, driven by a completely fabricated Facebook post. This orchestrated removal totally set the stage for the explosive transcripts that followed. Let's look really closely at the cross-examination of Clerk Becky Hill by the defense attorneys. The defense point-blank asks, "Did you tell the jury to watch his body language?" And Hill replies, "I did not." You can literally see her story beginning to fracture right here under pressure. Because immediately, that denial is flatly contradicted by sworn juror affidavits. Jurors testified under penalty of perjury that the clerk of court explicitly told them, "Don't be fooled by Murdaugh's body language. Look at him closely when he testifies." I mean, think about how massive that is. Those words actively shift the jury's perception of the evidence before deliberations even begin. This isn't just a minor procedural slip. It is textbook jury tampering happening right inside the courthouse walls.
When we review this, the outcome is honestly inevitable. The South Carolina Supreme Court unanimously rejected the state's argument that this tampering was just a harmless error. They erased the murder convictions entirely. They had to. They simply could not allow a court clerk to secretly influence a double murder verdict just to secure a guilty outcome. Allowing that would establish a terrifying legal precedent for every single future trial in the state.
Section 5. The retrial dilemma. What happens next?
Let's be totally clear here. The murder convictions are erased, but Alex Murdaugh is not a free man. He's serving decades for his massive financial crimes. But regarding the murders, the legal clock is reset to 0. Which leaves us with a massive dilemma to debate. Can a completely fair trial actually happen in a small town with this level of media saturation? Honestly, I am highly skeptical. Between the documented structural errors, the book deals, and the global media circus, finding a truly untainted jury is a logistical and legal nightmare. It's nearly impossible, and it's exactly what happens when justice stalls from the inside out. So what does this all mean for the future of our courts? Think about that. And we'll catch you in the next explainer.